for the most part, everyone has made it in. So thank you guys very much for joining us today. This is Scarborough University here doing a webinar on duty drawback. There's obviously been a lot of changes come down the pipe here in the last 6 months or so. So before we get in, or before we begin here, just a quick little commercial on Scarborough. Scarborough is a group of companies, and we are a U.S. licensed customs broker and freight forwarder. Most recently, we opened a consulting division. And today with me, I have Pat Caulfield from Grunfeld, Desiderio, Leibowitz, Silverman, and Kleystadt. Pat and I go back now a few years. We've played golf a few times together and know each other from a few events. And Pat's a great attorney, and I think you guys are going to have a good insight into some of the things about drawback. We will try to keep the PowerPoint side of this presentation down to about 20 minutes or so, and then we'll spend the rest of the time going through and answering questions. If you guys have questions, I know we've gotten a big chunk of them already. There is a Q&A option in your login as well, so please feel free to ask them. We will do our best to answer everything live. If we do run out of time, we will get every question answered that we do have. So without that, Pat, thanks for being with us, and I will let you begin.
My pleasure, Adam. Happy to be here. And as Adam mentioned, I'm with Grunfeld, Desiderio, Leibowitz, Silverman, and Kleystadt. We are an international trade firm in New York. We're headquartered in New York. We have offices throughout the country. We only do international and customs matters. And before that, I also worked at two customs brokerage firms. So today, we're going to talk about Drawback, which is one of the oldest export promotion programs that we have. In fact, Drawback was provided for in one of the first tariff acts going back to 1789. So it's been around for a long time, and as you can imagine, it's changed quite a bit from then to now, but the basics are the same. Drawback is a refund of 99% of duties and fees upon exportation or destruction of previously imported merchandise. So in its most basic form, if you import 100 widgets and export the same 100 widgets, you can get a refund of the duties and fees you paid when you export them. And when I say duties and fees, that includes regular duties, excise taxes, merchandise processing fees, harbor maintenance fees, but it does not include anti-dumping or countervailing duties. So you can get it on most of the duties and fees you pay, but not AD or CVD. And of course, the policy is to promote exports. That's the basics of drawback. Now today, I want to touch on a few topics on who can claim drawback, the timelines of doing so, and the main types of drawback. There's many different types. Today, we're going to go over the big ones. But that's the basics. So, and then we can move to the next slide. Okay, so who can claim drawback? Generally, the exporter of the goods, or as the case may be, the destroyer can claim it. But those parties can assign rights to the importer or to any intermediate party. The only caveat being that the exporter or the destroyer has to take possession of the goods before they're exported. And once they're exported, you can apply for drawback. Now, under the old drawback law, there were a few timelines you had to keep in mind. You had 3 years to export merchandise after it had been imported, excuse me, and then 3 years to file a claim. Now, under the new drawback law, which Adam referenced, which is fairly new, it only went into, only enacted about a year ago, it became official. It's a single 5-year period. You have 5 years to import goods, export goods, and then file your drawback claim. So part of the reason the new law was implemented was to simplify drawback, and that's one of the simplifications, just a simple 5-year period. I should also mention, in terms of exportation, you can export these goods into a foreign trade zone and be eligible for drawback. Merchandise, when it goes into the zone, has to be in what they call zone restricted status. For those of you who don't have familiarity with an FTZ, goods go into an FTZ in a status, and that status dictates what can be done to the goods in the foreign trade zone. when you import something in zone restricted status, it means it can't come back in. So an export to a zone, because it can't come back into the country, is considered an export for drawback purposes, and you can claim it if it's timely and if you are in proper drawback. So if we could, I think, maybe, I don't know if there's another slide here, Adam. Okay, we covered this. Maybe next slide. Okay. So this we went over. When is drawback beneficial? It's beneficial when you're importing and exporting the same product. But as I said, there's several different types of drawback. We're going to talk today about unused merchandise drawback and manufacturing drawback. There's other types. There's rejected merchandise drawback, and there is a statute for petroleum derivative drawback, which if anyone has questions on those, I'm happy to take them, or you feel free to email me after the webinar. I'll leave it up to you. But let's talk about unused merchandise drawback first, and within that, there's two different types. The first is direct identification unused merchandise drawback, and that's just that is just what it sounds like. It's like the example I mentioned earlier. If I import 100 widgets and I export the same 100 widgets, I can file a claim for a refund of the duties and fees paid upon importation. You need to be able to track those goods. That's why they call it direct identification. That can be done via lot number, serial number, or if it's a fungible merchandise, what they call a drawback accounting method. First in a warehouse, first out a warehouse, for example. But you need to be able to do that. You need to be able to track that and have the paperwork showing that the goods that came in are the same goods that went out, or if they're fungible, that you accounted for properly. You don't necessarily have to submit that when you make your drawback claim, but you should have that documentation available should customs ask. Incidental operations to the goods, these goods that you've imported are allowed, by the way. So if you import these goods, you can test them, you can manipulate the packaging. Certain incidental operations like that are allowed, and you can still claim drawback. So that is direct identification unused merchandise drawback. The second type of unused merchandise drawback is what they call substitution drawback. This is a little more complicated than direct identification merchandise drawback, because it allows you to say if you import 100 widgets, you can export a different 100 widgets and claim drawback on those. So again, it's like it sounds. If you bring in one type of product, you can export the same type of product, although it doesn't have to be the same merchandise that you imported. So the issue in this case becomes, what merchandise can I substitute for my imported merchandise? Under the old standard, there was a concept known as commercially interchangeable. So if I imported goods, I could substitute goods that were commercially interchangeable with those goods, export them, and claim drawback. Commercial interchangeability was a bit of an unwieldy standard. There were 4 factors that government would consider when deciding whether or not 2 different products were commercially interchangeable. They'd review government industry standards, part numbers, tariff classifications, and the relative value of the goods. So there was an element of subjectivity to it. Under the new drawback law, that again just went into effect last year, substitution drawback is dictated by an 8-digit tariff classification. So if you import goods that are classified under one 8-digit number, you can substitute those goods with anything classified within an 8-digit number, which is much easier. You know, classification, although there is some gray area in some classifications, it's much more objective than the commercial interchangeability standard. This being customs law, however, there is a caveat to this new 8-digit substitution standard, and it has to do with tariff provisions that are what we call other provisions. I'm assuming a lot of you guys in this webinar are familiar with the HTS classification system, but there are many codes in the harmonized tariff schedule that just cover other goods. So if the larger heading covers widgets, there's all different types of widgets that fall underneath it, and then there's a catch-all provision, which is another provision. So if the 8-digit HTS number is an other provision, you have to go down to the 10-digit. And the 10-digit numbers, the 10-digit number of the imported good must match the 10-digit number of the outgoing good. However, another caveat, if the 10-digit HTS is also an other provision, there's no substitution drawback allowed. So that is the caveat. Although generally speaking, the 8-digit standard is easier to implement than the commercial interchangeability standard, there is that caveat with certain provisions, which is something you should be aware of. That's substitution unused merchandise drawback. The next and last topic we're going to talk about in terms of drawback types is manufacturing drawback. And manufacturing drawback applies when you import raw materials or component parts of a larger good and incorporate them into a finished product that is eventually exported. You can claim drawback on those raw material or component parts, as the case may be, when that finished good is exported. The trick here is that the new product that you've incorporated those components and parts into needs to have a new name, character, or use. For anybody that's familiar with the substantial transformation standard, it's similar. The components and the raw materials have to be changed. It has to be a complete production. You also cannot include any of raw materials or component parts that were wasted in the manufacturing process. So if I bring in fabric to produce garments and I want to export those finished dresses or jackets or shirts or whatever the case may be, any fabric that I've lost in that manufacturing process, the value of it cannot be included on my drawback entry. It's only on what actually leaves. And in that case, you'll generally need a bill of materials for the finished good that you're exporting. So it's a little more complicated. But that is the long and short of manufacturing drawback. Again, it's also broken down, like unused merchandise drawback, into direct identification and substitution. So if you bring in raw materials, you use those raw materials and export them in a finished product, simple enough. It gets tricky when you bring in raw materials, substitute the raw materials into a finished product, and then export that. It's the same 8-digit HTS standard, but that's the basics, the ABCs of manufacturing drawback. And I think we have some time, so maybe I'll touch on rejected merchandise drawback as well. That is exactly what it sounds like. If you bring in goods that it's not to your, not what you ordered, or they're defective, or for whatever reason you have to reject them, you can return them to customs custody for export and claim drawback. Again, there's also other avenues other than drawback for rejected merchandise. You can claim defective merchandise under another provision of the regulations. So sometimes rejected merchandise drawback is not used because it's maybe easier to file a protest under defective goods regulation, but that's the long and short of it. Now, one of the opportunities you should be aware of in drawback is what they call matching import-rich companies with export-rich companies. So there are very few companies that are fully integrated for drawback purposes, meaning that you import the same product that you export. There are customs rulings out there that permit companies to match up. So if you are, for example, a wine importer that doesn't export wine, and you can find a wine exporter who does export wine, you can insert a third company in between them to act as a clearinghouse of sorts. You can claim drawback on their exports to cancel out your duty payment on your imports. Wine is a little complicated, but it's been one of the industries that has been drawback heavy, so to speak. And while that principle is allowed, one of the changes in the new drawback law affects excise taxes. Previously, wine users had been able to almost cancel out excise tax payments by taking wine produced in the United States that is generally subject to an excise tax and exporting it without entering it for consumption in the U.S. So there's no excise tax paid on the wine. If you compare that with a wine import on which you paid excise tax and then claim drawback on the export of the domestically produced wine, you would in effect not pay any excise tax and still have wine in the country. The new drawback regulations, which were just published, put an end to that. But I can tell you that that is a contentious area of the law, and you can expect that to be challenged in court. But the principle remains, it is permissible under the right circumstances to match companies that have exports with companies that have imports. So with that, I think that's been about 15, 20 minutes. If it's okay with you, Adam, we can open this up to questions.
No, for sure. So a couple of comments, just in general here. I'm going to kind of buzz through a couple of them.
You're right. We should touch on 232 and 301. I just saw that slide.
Yeah. Go ahead.
So just this slide basically says it all. The Section 232 tariffs are the tariffs that are applicable to steel and aluminum products. These were implemented back in March by President Trump under what they call Section 232 of the Trade Expansion Act. And it applies to certain steel and aluminum products, regardless of their country, that fall within particularly designated tariff classification. 25% tax on steel products and 10% tax on covered aluminum products. The government has said there's no drawback allowed on these duties. So if you import a steel product and you pay the 25%, unless you have an exclusion, you're going to pay it, and you're not going to be able to get it back if you export that product or find a domestic product that would meet that 8-digit substitution standard. Section 301 tariffs, by contrast, are specific to China. They were imposed by President Trump, the first batch of it starting in July, under Section 301 of the Trade Act of 1974. And these are punitive tariffs in response to allegations that China has engaged in unfair trade practices relating to intellectual property rights. These are still in place. Unlike the 232 steel and aluminum tariffs, though, Customs has said that drawback is allowed on them. So there's an opportunity, if you import goods from China that are subject to these additional duties, to export either those same goods or a substitute product and claim drawback on them that way. So that's the basis of 232, 301, and drawback.
So, Pat, let's go back to manufacturing drawback for a minute, because I think it's an area that there's a lot of confusion. And I don't think people necessarily know what is maybe considered manufacturing and what's not. So one of the things that I want to talk about is just the idea of, let's kind of lay out a simple example. Let's take my pen here, right? Mm-hmm. And if I import the ink part of my pen, right, into the U.S., I assemble it here in the U.S. with U.S.-made product, and then I export this entire pen back out. Is that manufacturing drawback?
So I think it's going to depend on the classification of the ink and the pen. If it changes, I'm sorry, can you you imported the ink, right?
Yep, I just imported the ink, and the rest of the body of the pen was made here in the U.S.
Okay, so the ink has to be incorporated into a new product with a name, character, and use. If I was going to make the argument that you were eligible for manufacturing drawback, you would say that the ink is different from the pen, and it was incorporated into the pen, and it can't be taken out, and it can't be used separately, and exported it, so it's a new product in use, that you would be eligible for manufacturing drawback. That would be the argument. I don't know if it would carry the day. It used to be under the old law that you needed to get a ruling or locate a ruling on your particular case before you could claim manufacturing drawback. That has changed somewhat under the new law because it's subject to the new liberal rules. You'd have to research the classification of the ink versus the pen, but that would be the argument.
So you brought up the old rules, and when we talk about old versus new, most of you have probably heard maybe the phrase TIFTIA, TFTEA. That's usually when we start talking about new rules. That's what we're referring to is the new TIFTIA language for drawback in general. But let's talk about those rulings for a second. Prior to TIFTIA, there was basically kind of like you said, two processes to do this, right? There were some general base rulings for drawback that were already out there. And then option one, option two, you basically write in an application to customs, kind of explain your process and why this is a ruling is needed. So what I'm hearing you say is that you no longer have to do that.
That's right.
So in those scenarios, when we get to that manufacturing drawback, instead of, because with especially the new Section 301s, we're seeing a lot of requests now for people to say, hey, I want to do drawback. There's benefit that exists at that 10% level that didn't used to exist.
Right.
So, what are their next steps? Is it still kind of lining out what does that manufacturing process look like and maybe mentally kind of thinking through, if I was requesting a ruling, this is what it looks like? Or would you recommend they kind of go a different route?
No, that's exactly the route I would go. I would certainly line it out before I started to do it to make sure it could qualify, because you want to be able to substantiate anything you submit to the government, because it's always subject to being challenged. And if you're wrong, you'll have to pay the duties. And there's always a chance, although if you acted in good faith, you should be okay, but there's always a chance that they can issue a penalty if you owe the duty. So you would want to make sure your T's are crossed and your I's are dotted before you went ahead and claim that drawback.
No, that definitely makes a lot of sense to me. So let's kind of keep on the same old versus new. And you talked a little bit about that substitution. So I kind of want to go back to that for a second and kind of break that into two parts, right? You have the which it's a big win, right? That 8-digit level HTH match. So to give some folks on the call maybe a scenario, I have a customer right now that imports the exact same item from 4 different countries, and the 5th country is actually a domestic supplier. And all of those get commingled together, as in they all get thrown in the same bin.
Mm-hmm.
So when that product goes to export, can they still use that 8-digit and claim that drawback?
Yes, they can, as long as it's not an other provision. So if
right.
you go down to the 8-digit number, is it an other provision? If so, you have to go down to the 10-digit number. If the 10-digit number is not another provision and it matches, the drawback claim is valid. But if the 10-digit number is also another provision, you're precluded from using substitution drawback.
So in that case, we've actually taken, with the new TIFTIA language, you've actually taken away some ability for substitution. You have
in those scenarios.
Right. And so we always caution our importers and I hate to use the word, but I'll say them, is to kind of stay away from that other provision, right? Because
to the extent you can.
It's this big swath of lots of potential issues. And when we see folks get in trouble simply from a classification perspective, it tends to be in those other type provisions. And so this is just another reason, as any of our importers are going through the process and trying to classify something, to say, I ended up in other. Maybe I should take a second look. Maybe I should ask the advice of somebody, look at it again. I understand that, hey, if it's duty-free, it looks great. Believe me, that makes a lot of business sense. But at the end of the day, as you kind of look at at your supply chain as a whole and your import compliance program as a whole, there's obviously some things out there that would maybe make you rethink that or kind of look to say maybe there's something a little bit better.
Right. And look, drawback's a great way to recover duties if it works for you. But if you're looking to mitigate the effect of these China tariffs or the steel and aluminum tariffs, and drawback doesn't work for you, there are other avenues that you may want to look into. With 232, there's an exclusion process. For 301, the available exclusion processes have closed. They can always reopen them, but there's been no indication of doing that. But there are other avenues to mitigate that tariff in the event that this other provision knocks you out. For example, the first sale program or moving production, at least partially out of China. Just because one door closes doesn't mean that you're necessarily totally out of luck.
Right. All right. Well, so I'm going to kind of switch gears here and talk a little bit. We had a lot of questions that got sent in prior, and I know we have a couple coming in live too. So I'm going to let those coming in live build just a little bit here. Just some basic ones. For duty drawback, do I have to have a customs attorney? Do I have to have a licensed broker? Who do I need to contact to kind of get that process going?
A claimant's free to file it on their own. I think they'd be better served by having an attorney or a broker do it, someone with knowledge of it. These drawback regulations and rules are very complicated. There's a lot of caveats, carve-outs, deadlines that if you're new to the program, I think you'd be very well served by having someone who's done it before, and I know Scarborough can do it for you, file these, at least guide you through the process. At least in the beginning, I don't think you have anything to lose by asking them to help.
Right. Usually, we file the claim, you file the claim. How long, in your experience, do you usually see it to take to get that refund? Now, let's exclude the accelerated payment option, which we can talk about, but just in general, about how long do you usually see that take?
Okay, well, just to get, Adam mentioned the accelerated drawback program. That's something that you apply for, and if you're accepted, the refunds, I think they're guaranteed or they should be issued within 30 or 45 days. Outside of that, it can take quite a while to get a refund. It depends upon the person reviewing it and the port. Not all customs officials are necessarily fungible. Some are quicker than others, but I would say on average, you're looking at months rather than weeks.
I would agree. I think the longest one we've seen, I believe the statute is they have to pay within 3 years, or it was. And so we've seen some actually get close to pushing that 3-year mark. So we always advise. Yeah, we always
Those
advise.
Those are the outliers, though.
No, absolutely. To go through the process, go through the application for privileges. Let's get some of that set up so you get your money back a little bit quicker. Because nobody wants to.
Drawback is generally worth it.
Correct. So, kind of along those same lines is, if I'm the importer of record and I sell the product to you, Pat, and then you turn around and export that product, can I claim drawback, or is it just the person I sold it to that they can claim drawback?
You could claim it. I would have to assign you that, though. The way the statute's written, it's the exporter, or the case may be the destroyer, unless it's assigned to an importer or the importer of record or an intermediary. So the exporter would have to assign that right to you, but you technically could.
Right. So basically, either party could actually claim.
Right.
Correct. And so we get a lot of confusion in that is someone's always like, well, I'm this or I'm that, so I can't claim. Well, in all actuality, there are a lot of benefits, or there's a lot of options for you still to claim, even if you're not necessarily the exporter.
That's right.
So here's kind of a question, kind of going along that same lines, more of an opinion type question is, what's your biggest tip about duty drawback? Is there one pitfall that you see importers, exporters make all the time if you could say, if you would have engaged us at step one, this would have been the one area we would advise you to take a look at?
Well, every drawback claim is different, but the common thread that applies to all of them is time frames. Biggest mistake I've seen made, and it's happened more than you think, is that you submit the claim and you think it's done. A lot of times customs will issue a notice to you after the fact asking for more information that you might miss, you might overlook, you might not think is that important, and you let it sit. And then the deadline expires. Customs is taking a position in a lot of scenarios that if you don't give them the information they need within that 5 years, it's time barred. We've fought that and we've won in some scenarios, but in other scenarios we've lost. So my advice would be to just keep an eye on that deadline and be very prompt in getting customs any information they need. That's the common thread amongst all drawback claims.
So you brought up the time at the beginning. We kind of used to have that 3-3 type scenario where as long as we filed drawback within 3 years of export, and as long as the export was within 3 years of import, right, we could claim that retroactive drawback. Right. And now we've shifted to the 5-year solid scenario, right? If it happened in the last 5, let's go claim it. But let's talk about that a little bit, because something that we see a lot is someone will approach us. Maybe they're new in compliance at their current job, and they say, hey, we would love to participate in the program. We haven't claimed drawback for the past few years. And then all of a sudden we start to work down the line and realize they've already done that retroactive claim. And so, just to know that it's kind of a one-time get out of jail free card.
Right.
It's not a constant, nonstop, I can just wait once a year and then go back and get it retroactively. Right,
because there's this concept of prior notice. If you give customs notice of exportation or destruction, and if you don't do that, it generally can undermine the claim. However, customs gives you a one-time pass where you can retroactively claim it. This is what I was referring to. So if you're going back and you haven't been claiming drawback, you really get one shot at it to get all the retroactive money back.
Right. So, what we always advise clients in this kind of a scenario is, let's pick a day to start providing notice of intent. And then once we draw that line in the sand, then we'll file our application for privileges to kind of get that one-time waiver of prior notice. But what we see a lot is folks will file that waiver today, say, yeah, we want to do this, let's get going today because we have all this money that we think we can capture, but they're not ready internally to kind of get through that. Hey, we have to notify, whether it's my broker, my attorney, or customs myself, that's saying we want to file drawback. And so for me, that's a big area that we always advise, because we do a webinar or we talk to somebody and we see some opportunity, they're ready to go really quickly. And where we run into issues is that we file that one-time waiver and then we lose out on 3 to 6 months while we're trying to get ready to actually start a full-time drawback program.
And that's a great point, Adam. And I think that, someone asked earlier whether or not it's worth the effort of engaging someone to walk you through that process. And I think that's a great example of why, if you're not super familiar with drawback, you may want to engage someone that is.
For sure. So here's another question for you is, does U.S. Customs require the filing of duty drawback at the part level, or in this case, just style, quantity, and sizes? So we're talking about a textile company here.
I'm sorry, what was that last part? You kind of broke up.
So as a textile company, does Customs want me to report at the SKU level as far as what's being exported, or can I just report at the style, quantity, and size level?
I think it depends on the type of drawback you're using. For a direct identification drawback, you would use the SKU. Each product's got a SKU. You would use that. But as a substitution drawback, it just has to be within the 8-digit classification number. So
Right.
anything that falls under that, regardless of the SKU or the style, could qualify.
Makes sense. So we have another question, kind of along those lines, is that so it's a question that came in live here. It says, we import boards that are to be repaired and returned that have a country of origin China. When we export them, can we claim duty drawback? And to me, the quick answer to that is yes, probably.
Yeah, that would be my take on it too. So you import it and you export it. It sounds like it would be direct identification since you're repairing them, but maybe it's substitution. In any event, there's nothing that would necessarily preclude you from claiming drawback. And even assuming that these products were classified under a provision that's subject to the additional China tariffs, you'd be able to claim that back too.
For sure. So here's another question that came in live. Are there different documents required between a drawback if you're claiming that you've destroyed merchandise or if you've just exported the merchandise?
That is a nitty-gritty question. I used to work at a brokerage firm, but it was a long time ago. I think that the answer is yes, especially because destruction generally has to be done under custom supervision. And I know there used to be different forms, but now with the change from ACE, as well as from non-TIA to TIA drawback, I don't know that answer with 100% certainty offhand. I don't know if you do, Adam, but I would imagine there are different forms, or at least the form has to be filled out differently.
I was going to say, from a form perspective, we're really talking about the same form, right? We have the 7551 and the 7553. But so from a form perspective, but it's really that backup documentation and that notice part that starts to change, right? From an export perspective, we provide notice to customs. We have to give them 72 hours to say yes or no, we want to examine that product. Assuming they don't, we're allowed to just export that product. It doesn't have to be under customs supervision. Once that product's exported, we can provide our paperwork and submit our final drawback claim. In that export scenario, kind of like you talked about, in the destruction scenario, the majority of time that we look at a destruction option, it is in that customs wants to supervise it, because customs idea of destruction and our importer's idea of destruction may not always be the same thing. A great example, you talked about alcohol earlier, is that if you want to destroy alcohol, customs will want to physically watch you break the bottles in the dumpster. Because just throwing them in a dumpster does not mean that you've destroyed those items. Now, whether you and I would go dumpster diving to drink, it's a different question, right? But as far as what customs thinks as actual destruction, that doesn't count. So we see it with textiles, how they have to be cut and ripped in a certain way, right? So they can't be stuck back together. So when we start talking about destruction, there are a lot more caveats to some of that than there is on the export side. Destruction is also very difficult to claim in that waiver of prior notice. We've done it a few times. We've done it because there's been certificates of destruction. There's been pictures. There's been a lot that came from that destruction company. But in a lot of instances, we've seen that customs doesn't allow those items simply because they can't really prove that they were destroyed. So another question that just came in, with the new TIFTIA language, does it really affect anything if I'm shipping items to Canada? So is there anything within TIFTIA that kind of calls out NAFTA that says, the drawback process is going to be a little different?
Well, NAFTA, I'm glad someone brought up NAFTA, because it's not necessarily in TIFTIA, but NAFTA itself, there are limitations on drawback. NAFTA, the old NAFTA, which ironically is the NAFTA that's still in place now, even though it's been renegotiated, eliminated the ability to file unused substitution drawback on exports to Canada or Mexico. It also limited manufacturing drawback to the extent that you would get if you claimed manufacturing drawback on an export to Canada or Mexico, rather than automatically get 99% of the duties you paid, you would get the lesser of that 99% value versus the value of that good when it was imported out of Mexico and Canada into the U.S. in the first place. So there was a limitation on it. I believe those provisions were largely left the same in the NAFTA renegotiation, but that's very much in flux. It hasn't been passed by Congress yet. So it remains to be seen how the new NAFTA would change those rules. But in the old NAFTA, there were restrictions, even irrespective of CETA.
Right. So, kind of like you said, with USMCA or the new NAFTA, NAFTA 2.0, whatever you want to call it, we have a scenario that we're not quite sure yet. So we do have a lot of questions that kind of came in. How does the new NAFTA, how does USMCA impact drawback? And that is a little bit different because we don't quite know yet, right? There's a lot of language. And for those of you who maybe don't follow it too closely and maybe just follow it at the national news level, you might see things like, oh, then the new NAFTA has been signed. Well, what does that really mean? And what we tell folks is there's still a lot that has to get ironed out. So basically you can kind of think of the signing down in I think it was Argentina earlier this year, or I guess I should say late last year now, is more about an agreement in principle, right? It's not the weeds. It's not the ins and outs necessarily that I know our customer base is really looking for, because it's not there yet.
Right. And just, to that point, you've got this new, well, let's take the old NAFTA, which, like I said, is the NAFTA that's in place now. So there was the NAFTA agreement, which then had to be signed into law. Congress had to approve it. Congress has to approve this new NAFTA as well. That gets added to the tariff. And then there is an entire section of the regulations that had to be added, filling in all the blanks and all the uncertainties in that agreement. And that needs to happen for this new NAFTA. And the new NAFTA hasn't even been approved yet, so it's not even in the tariff. So that should just give you an idea of why there's so much uncertainty. You may be able to get the broad strokes of the new NAFTA, but filling in the nitty-gritty on how it works, what's allowed, what's not allowed, that's a long way off.
Right. No, I agree. And my gut tells me that if we know a lot of those details by the end of this calendar year, I'll be pretty happy.
Yeah, I think we'd be pretty lucky.
Yeah, no, I would agree with that 100%. We kind of have just some other random questions that aren't falling right on in. A question that just came in is the 1%. Is that you hear us talk a lot about the 99% that you can get back, and Customs does keep the 1%. And if you really get into it, a lot of that 1% is simply about Customs saying they have a cost of doing business, right? There's a cost of money. They have a cost of doing business. That's the 1%. And I think really the question that has to get asked is, what's an importer going to pay for this service? And it's a little bit different. Everybody charges a little bit differently. What I still think is probably some of the most common is some kind of a percentage of what you get back you pay to your service provider. I'm not exactly sure how you guys work through it, Pat, but that's how we work through it. That's how most of the brokers that I know just throughout the business, that's how most of us kind of work through this. It's kind of a sliding scale of a percentage back. So are you guys similar to that? Because I think that's a common question. Well, how much is this really going to cost me?
We can work on that basis. In our world, it's called a contingency fee, and we certainly do work like that. Other issues we work on more of a time expended basis. It depends upon the issue. Certainly filing a drawback claim is one thing, but a lot of times when we get involved in drawback, there's been a problem,
Right.
and a drawback claim's gotten denied, and we have to file a protest, which does lend itself to a percentage recovery as well, but also sometimes a company might want to just pay on time extended. It really depends upon the situation.
Right. No, absolutely. A question on record keeping is how long do we have to keep the backup for drawback record keeping?
I believe the new law said 3 years, but the general customs provision is 5 years. So I think the answer is it's a minimum of 3 years, but I would recommend the full 5 years just to be in line with the customs of record keeping requirement.
No, I would agree. And I think this kind of highlights, and there's a few other areas where customs kind of contradicts itself as it goes through new things. And there's record keeping requirements that say 5 years from date of entry. And now you have anti-dumping cases that kind of get excluded out of that, right? Then you have drawback claims that change that. So 5 years is usually a pretty safe number. We also recommend after the 5 years you get rid of them because nobody needs to keep that stuff around any longer.
That's right. Once the statutes run, no good day.
Absolutely. A question here, one about some minor assembly work and then one about a foreign trade zone. So on the minor assembly side, we import parts used for agricultural equipment. We warehouse them here in the United States, maybe do something like you said, pack them, change their packing a little bit, and then we export them to our dealer network in Canada. You know, we're the importer of record in the United States, and we're also the non-resident importer in Canada. Is this a fairly clean drawback process? Now, obviously, there's still lots of ins and outs, but simply from we import stuff into the U.S., we're the exporter out of the U.S., and then we are the importer. In my opinion, I would say, yeah, it's pretty cut and dry.
But the question was to Mexico, right?
No, Canada.
Canada and Mexico, the NAFTA, you may run into a problem there, but this is just substitution drawback. You may run into a problem exporting it to Canada.
Right, and getting that back. But I think overall, there may be some tweaks inside of NAFTA that either preclude it or just make it a little bit more difficult. But the idea is, if you're the importer, you're the exporter, and then you're the non-resident importer somewhere, for the most part, that lines up very easily for a lot of that documentation flow.
It certainly does, but I would just be careful about if this is indeed going to Canada. I don't know that claim would necessarily be approved. There are some restrictions. Generally speaking, unused substitution drawback was eliminated by NAFTA. So, while the structure works, we should look into further whether or not it would be a viable claim because the goods are going into Canada.
Got it. So a question about an FTZ. I work in a manufacturing foreign trade zone. Can you speak on that again as the eligibility and zone status requirements? They import engine components, they build the engine, and then they export either the finished engine or maybe just components.
So the goods are entered for consumption into the United States.
No, the goods are entered into a foreign trade zone.
Right.
And
they're manufactured in the zone and shipped out?
Correct.
So what if you import them into the zone, though, doesn't that go in duty-free?
Exactly. No, it's just a question. It's some of the stuff that's coming in. I just want to make sure that we're all kind of on the same page, is that with the foreign trade zone, as things do come into the U.S., as you put things together, you can then re-export them and you don't have to deal with the duty drawback process. And if you have, foreign trade zone is, we did a webinar on it. I think we've done at least one, maybe two on it so far. So if you're interested in that, take a look, give us a call. But there are a lot of different things to do to kind of get around needing duty drawback if you're inside of a foreign trade zone.
That's a good point. And just to clarify, when I brought up foreign trade zones before, it had to do with whether or not movement into a zone was considered an export for drawback purposes. And the answer, in short, is yes, provided that you never re-import those goods into the United States. And it's called zone restricted status. You have to declare the goods as zone restricted status, meaning that they can't come back into the U.S., but that is considered an export for drawback purposes.
Right. So really there's two sides to that, right? If you import into a zone, you do something in a zone, and then you send it back out of the country, you never pay duties, therefore you don't need duty drawback. You import something, you pay those customs duties here in the U.S., and then you sell it, but when you sell it, instead of exporting it physically out of the country, you export it into a foreign trade zone, then you can still get that benefit of duty drawback.
Right. Exactly right.
So one of the questions kind of along those same lines is foreign trade zones are a little bit more intensive to set up, especially on the front end. They require a little bit more record keeping, right? Your inventory has to be spot on, And for us, we get a lot of a question, well, I'll just do duty drawback or I'll just do foreign trade zone. And we always advise people, let's take a look before you kind of decide either way, because even though you may be paying 20% recovery, right, against your duties, that still may be cheaper in the long run than setting up a zone, or vice versa. Maybe paying that large percent recovery, maybe it's a better deal to get into the zone. So it's not really a question that we can just answer and say, oh, do the zone or do duty drawback. It's something that we need to look at on a case-by-case basis.
Yeah, there's a lot that comes with a zone. The setup, you have to maintain it. You have to have the record-keeping procedures in place. There's some periodic filings you need to make. You're right. It may not necessarily be the best thing. It depends on the particular import and the particular product.
Right. Another question that came in here is we previously imported paper honeycombs from China. When they arrived in the USA, they were a total loss due to water damage. Is that eligible for duty drawback?
Yes, rejected merchandise drawback. Alternatively, there's a regulation, I think 58, where if you don't want to file drawback, you can file a protest claiming that the importation had no commercial value and ask for a refund that way. So you should be able to file a claim to get the duty you paid back. I know there's an anti-dumping order on honey from China. I don't know if that particular product is covered. If so, the protest might be a better route because you can't recover anti-dumping duties via drawback. But again, it depends on the facts.
Right. So kind of an opinion question. I'll give mine, and then I'm kind of interested in yours, Pat, is what are some of the biggest challenges when filing for duty drawback? And for me, what I see is that we don't necessarily have all the facts going into that very first claim, right? In making sure that we have the records that support what we want to export and what we want to claim drawback on. I think the biggest thing that we see is just lack of record keeping and an ability to tie those imported records back to any specific inventory sitting on the floor. How about you?
I agree. I think record keeping is absolutely the biggest issue. It's the most common issue I see when there are denied drawback claims or requests for information made. It's either that customs didn't have XYZ or the notice is asking for information, they want to see it. But I 100% agree. The biggest issue I think is record keeping. And
okay.
Record keeping in the sense of the records that substantiate the claim.
Right, not the drawback records.
Right.
For sure. We touched on this earlier, but I want to just touch on it again. We did get a question that, Section 301, those Chinese tariffs, yes, we can claim duty drawback against those. And Section 232, the steel and aluminum tariffs, no, we cannot. And so, that's been kind of a big issue with that. If there's more specific questions, please feel free to Fire away. So we get this question a lot, and I'll let you lead the charge on this one. Is how do I know if my company's really going to benefit? Like, is there a benchmark number that says, if you think you can save X number of dollars in a year, yeah, it's probably worth it to go look at duty drawback. That's a question we get all the time. Is before I go down this road of hiring you or going to a customs attorney, just give me your gut take. Do you think it's worth it?
That depends on the company, and you really have to run the numbers. And you can go back.
Mm-hmm.
So, two things to keep in mind. How long have I been exporting this? How far back do I think I have viable drawback claims? And like you said, Adam, your fees are generally a percentage of the recovery, so you generally won't lose money. And then going forward, if you still think you're going to continue to export, it will pay for itself, because those are fees that you will continue to collect as you export.
No, absolutely. And so what we like to tell people is, if we're getting ready to do that look back period, right? Trying to go back, if you're not getting a check $10, $15, $20,000 that first time around, it's probably not worth it, because the amount of time and energy it's going to take to really get all that record keeping to kind of do that one-time waiver of prior notice, right? Like there needs to be a substantial win there.
Right, and that's going to depend upon the company.
Right.
If I'm a smaller company, a $10,000 figure might mean more to me.
Absolutely.
Than a bigger company.
No, absolutely. And so to me, that's always kind of where, if you're not getting that kind of money back, it's not that we won't file it. It's just that we say, this is going to take a lot of work as you start to look through all of this. Do you think it's worth it or not? And you're exactly right. It's very much a case-by-case, business-by-business decision as far as what does that look like. We only have a couple of minutes here, so I want to ask you a question, especially as a customs attorney. Do you feel that filing duty drawback opens an importer up to more scrutiny and targeting by U.S. Customs?
No, not in the sense of a bad thing. If you file a drawback claim, anything that you file, it's subject to question. Customs, generally may not just give you the money back. They may have several questions on that particular claim. But I don't think it makes you any more likely than your average importer to be subject to a customs audit.
I would agree with you. I don't think that.
That's in my experience.
Yeah, no, I would absolutely agree. We have a lot of customers that participate in the program, whether it's through us, whether it's through you, a consultant, somebody else involved. So I definitely don't think that it really raises the red flag too much. I think misclassification, or what we really saw is when these new Section 301s came out, right? It was a good opportunity for people to go look at their tariff classifications, and you had good actors saying, well, maybe it does and maybe it doesn't. But of course we have those bad actors too that said, wait a minute, I'm just going to say now it's this tariff and it no longer applies. So to me, those are the types of things that bring on a lot more scrutiny than now I'm going to participate in the duty drawback program.
That's right. I mean, the drawback program's there for people to use, just like the import program. And just by virtue of exercising your right to do so, it isn't really going to bring any undue scrutiny. Like you said, it's when you start playing games and you get caught, that's when you'll start to see more scrutiny. Customs only has limited resources. They're going to focus them on their known bad actors, more so than just random checks on your good faith importer or drawback.
Absolutely. Well, with that, I think I'll double check the iPhone time here, and it is definitely 2:30. So we want to respect everybody's time. Pat, thank you very much for being on this. Just as another note to anybody that was on this, go ahead, check out Scarborough's YouTube channel. This will get posted out there. It will get a link, will get emailed to you. And then if there's a question that you like the answer to, we will also post just each question and answer individually there out on YouTube as well. So please go take a look. If you have another question, reach out to myself, reach out to Pat. And with that, Pat, thank you. Have a great day.
My pleasure. You too, Adam. And nice chatting with everyone. I hope it was enjoyable and helpful.
All right. Thanks, Pat.
Bye-bye.
Bye-bye.